The final video lecture for Legal Dimension of Europe. Today we're going to talk about monopolies. And the technical term for a monopoly under European competition law is abuse of a dominant position. Hence the title in the corner here. I'm going to use the word monopoly as well, because you know it of course from the game. In fact, I actually played a game of Monopoly yesterday evening. I lost terribly, but that's a coincidence. Well, the bananas will be explained as well in this class on the basis of the infamous United brands, also known as banana case. And the other two pictures, of course, the hands with the money, are about the problem that we have already discussed last week, that people that have monopolies also like to make some extra money for free and are maybe not playing by the rules. And the last picture here is the European geographical area, and that is also a relevant aspect of today's class because we're going to talk about markets. And when we talk about markets, we also need to talk about geographic markets. So, the article that is central to today's class is Article 102 of the TFEU, and that article will be professionally dissected today, the same way as we've done last week with Article 101. We'll go through each element of the article, give some case law, some explanation, so you can apply it to a specific case. So the key aspects of the article are abuse of a dominant position. Then we go to the relevant product market, and then we go to the relevant geographic market. And these two markets, the product market and the geographic market, they are important to establish whether there's a dominant position, because the dominant position is always there in relation to a certain market. So that's why we need to go through product market and geographic market. So the article 102 TFEU. What is prohibited under European competition law is the abuse by one or more undertakings of a dominant position within the internal market or a substantial part of it that is prohibited as incompatible with the internal market, insofar as it may affect trade between member states. That's more or less a paraphrase of what you find in the article. So again, here in yellow, we've highlighted the important elements of the article that we will say a bit more about now. Before we go to the article, an example from the news. One of the cases that Google was involved in, and this is the example of the 2.4 billion fine that was imposed by the European Commission on Google for basically abusing its dominant position in the search engine market by favoring its own related companies in their results, in their hierarchy of results that would appear on your screen. Now clearly Google is a monopolist in the search engine market. Everybody uses Google, some people don't, but let's say over 95% of us do. And by favoring your own companies or your own affiliated companies' undertakings in your search result, that is clearly not what you should do if you have such a strong dominant position on the market. So for that, Google was fined. If you find it interesting, you can look up this case, of course, and we might discuss it in the seminar as well. A couple of forms of abuse, and these correspond, of course, to the forms of abuse that we've seen under Article 101. So we don't have to say too much about it, but just for your understanding, we have the same structure in this article. So we start with a prohibition of something that is not allowed under European competition law, and then we look at some specific forms of abuse. So what does the abuse consist in? Well, for example, imposing unfair selling prices, for example, limiting production, for example, etc. So mind you, these are examples. And what Google has done, for example, favoring its own search results, is not in this list. So you could say, it's a different form of abuse. So these forms of abuse are highlighted in the article to give us the most common ways of abusing a dominant position, but they're not exclusive. What is a dominant position? Now, before we go to the, let's say, more specific legal interpretation of what it is, just for our understanding, a dominant position, according to many economists, is described as a situation of economic power over customers or suppliers over a certain period of time. So when there's this kind of dominance, where some company has clearly a power position in the economic sense over its suppliers or over us consumers or other customers, then we speak of a dominant position. Another definition, freedom of action or of absence of risk for an undertaking. And so basically, if a company can behave in such an autonomous manner that it doesn't matter much what it does, because it has such a strength, such a grip on the situation, and by that it sort of has no risks anymore to operate, that is what we should think of when we talk about a dominant position, a monopoly. If we go to a more legal interpretation, we can introduce the so-called United Brands case from the European Court of Justice. And that's also sometimes nicknamed the banana case, because bananas were the main topic in this case. The definition that we can find of a dominant position in that case is a position of economic strength enjoyed by an undertaking which enables it to prevent effective competition and being maintained on a relevant market by giving it the power to behave to an appreciable extent independently of its competitors, customers, and ultimately of its consumers. So you see, it's very similar to these other definitions that we have been given. I will explain the United Brands case in the following slides. But before we do that, a little bit about some indicators of a dominant position. So how do we know that a company, an undertaking, indeed has a dominant position on a market? Now with Google it's very simple. We simply know because every time we look for something on the internet we use Google. So somehow we have an intuitive understanding why Google is a monopolist or has such a strong dominant position. And that's also the first point on this slide. You can look at market share. And we know that Google has a huge market share. I just mentioned something like 95%, maybe even more. And that is of course the very first indicator of dominance in the market. The rough guideline that the European Commission uses is that if a company, an undertaking, I will use the legal word, has less than 30% of the market share, there's usually the assumption that it does not have a dominant position. If it has more than 75% of the market share, the assumption is that it has a highly dominant position. And sometimes that's also referred to as superdominance. Now in between 30% and 75%, you could call it a certain gray area. So in between 30 and 75%, other factors are also relevant to take into account to determine whether an undertaking has a dominant position. For example, what is the structure of the market we are looking at? What is the largest market share of the next competitor in line? Now, let's say that company A has 45% of the market. Company B has 4% of the market. And company C 3 and D 2 and so on and so on. There's still, relatively speaking, quite a dominant position for company A having the 45%. But also we should look at other competitive advantages, such as how strong is the portfolio of the company in intellectual property rights, IP rights. How many patents does it hold? How many trademarks and does it have? How strong are the trademarks? If you think of some companies have brands that are so strong that also exerts a certain dominance. Coca-Cola, for example, Apple, and so on. Also the resources of the company. How strong is the company in terms of its reserves? How much money does it basically have? How much assets does it hold? How strong is it in a technological sense? That's of course strongly related with IP rights, intellectual property rights, and patents especially. And Apple is again a good example there, having I think one of the largest resources in the world for technological companies. Not so strange if you look at the prices of their phones. And the next thing we can look at is vertical integration, and that means how much control does the company have over its vertical supply chain. If it has a strong grip on that chain from production to, let's say, the consumer, if it's very strongly integrated, that could also be a sign of dominance in the market, a dominant position. And finally, conduct is also sometimes brought into the mix, which is a bit confusing. But the European Commission and the court also take into account how the company has behaved, as it's actually abused its position, which is a bit strange to bring in, because you could say you first establish the dominance of the undertaking and then we look at whether there was abuse. But even the abuse itself is sometimes taken into the mix of determining whether there's dominance. So this is based on the analysis that the Commission makes of the position of the undertaking, and it might give you some ideas of what we're talking about. And so this is especially relevant between the 30 and 70% market share. So just to reiterate, having a dominant position on a market is not itself illegal. It's not illegal to be dominant in the market. What is problematic is when you abuse that dominance and when you use that power in the market in a way that is basically illegal, basically abuses your position. So we have many big companies, many of them out there. Mainly the technological companies are known nowadays, like Google, Apple, Facebook, Twitter, you name it. Or Shell, or in the oil industry and so on. So there are many dominant companies, but that's fine as long as they don't abuse their position. Now, we've talked about dominance in the market, but we haven't talked about what the market actually is. And this is an important thing to do. It was already important for last week when we talked about cartels, but today we're going to focus a bit more on the market. What is actually the relevant market? We need to know this because only if we know what the market is, we can know if there is a dominant position. Because the dominant position is always in relation to a certain market. So, what is a relevant market? Roughly, the relevant market consists of two markets, the product market and the geographic market. By the way, what I'm saying now and what I'm going to explain now is largely based on this banana case, the United Brands case that was already introduced before. So in the United Brands case, the European Court of Justice also explained that this product market and geographic market need to be determined, and they gave us, readers of the judgment, some indications on how to do this. Start with the product market. So basically, a product market is a market where products are sufficiently interchangeable or substitutable. So cookies that are similar or the same, we see some examples on this side. They're part of a certain cookie market, you could say. Milk, part of the milk market, or maybe the dairy market, depending on how substitutable the products are. And would you buy more milk if the yogurt gets more expensive and so on? That's the question. I don't think so, but maybe that could be one market. I'll explain that in a second. Anyway, you get the idea. So it's about how interchangeable the products are, and that determines what the market is. How to properly do that is by looking at demand substitutability and supply substitutability. How does it work? For demand substitutability, so we, the consumers, have a certain demand for a product, right? So we are demanding, we're on the demand side of the market. So what is very important here is so-called consumer behavior. And the European Commission has used in the past a so-called SNP test to determine what the substitutability is on the demand side of the market. SNP stands for Small but Significant and Non-Transitory Increase in Price Test, the SNP test. What does it mean? It basically means that consumers are asked that if a certain product that is close to another product would be raised in price, whether the consumer would change to the other product because of the price raise. It's a small but significant raise in price. If the answer to that question is yes, I would change to the other product, then we have one market on the demand side. So to make that a bit less abstract, if we have bananas, like in the banana case, and the bananas would go up 5% in price, or 10%. So you would pay €1.10 instead of €1, something like that. Would you go for apples next time you go to Albert Heijn? If the answer to that question is yes, then there is one fruit market, or rather one banana apple market at that moment in time. But of course you can ask the same question for other products. Would you buy more pears? Would you buy more grapes? Would you buy more, and so on? Every time the answer is yes, we sort of broaden the market. Now this is extremely important, of course. Why is it important? Because your percentage on the market depends a lot on how large this market is. Because if we're only talking about bananas, in other words, if the answer to the question, would you buy apples if the bananas go up in price, would be no, then we would have only a banana market. And then the relative percentage of market share would be huge all of a sudden for the banana companies. And that was exactly what it was about in the United Brands case, because the United Brands were producing bananas, and the question was, how dominant are they on the banana market? And yeah, so I hope you get the idea of this demand substitutability, difficult word. There's also a similar test on the supply side. So this is where we have the producers. And so we just talked about the consumers, but what about the producers? And there the question is how, and I think I actually had some separate slides for this. Here we have, sorry, I should have shown this when I talked about the fruit banana issue. So here we see again that you would have either a fruit market or a banana market. And the question that accompanies it, would you, oh sorry, now we're on supply, so I can continue. So on the supply side, we talk about the producers. So the question there is there a capability of other producers that may produce different products to easily change their production methods to enter the same market? So question, here we have it, can any other producer easily and cheaply enter the product market by simply adapting their production? If the answer to that is yes, then on the supply side we also have a bigger market. For example, we have a book market and we have paper producing companies. The question is, can these paper producers quickly change to produce books instead of maybe cardboard or something like that? I think this is difficult in this case, in this example, but let's assume it's easy for these paper producing, cardboard producing factories to make books, print books. If the answer to that is yes, then they are included in the same market. Or if we stick to the bananas, how easy is it for farmers that produce apples to change to bananas? If it's easy for them to just plant banana trees, then they would also be part of the supply market. Now, I can tell you that answer is no, it's not easy. First of all, we can't even grow bananas properly, for example in Holland, where we grow apples. And it takes, of course, a long time to adapt the production and so on. But this is the idea. So, now we understand what the product market is. So for product market, we need to know the demand and the supply substitutability. Once we've done either the SNP test or we've asked this question, is it easy for producers to change their production to become part of the market? We still need to answer the question, what is the geographic market? What area are we actually talking about? And this is a bit easier. The geographic market is basically nowadays, most of the time, the entire European Union. Why is that? Because the rules within the EU are largely the same. And that's the whole idea, of course, of the internal market. That the legal systems have been changed to an extent that the market conditions in the whole geographic area of the European Union are the same, or at least highly similar. It doesn't always need to be the case. There might be some exceptions when you talk about very heavy industrial products or mountainous areas where transport is difficult. You might say that under certain conditions the geographic market might be smaller. In the United Brands case, for example, the geographic market was not the entire European Union because some of the EU countries, like I think it was the United Kingdom and France and Italy, I believe, well, there were 3 countries that had specific market conditions because of old colonial ties with the banana producing countries. So they had different agreements and contracts with these countries, more beneficial actually, because of their colonial pasts. So in that sense, they had a separate geographic market there. But most of the times, it's the same European Union market. So the definition is a substantial part of the internal market where the allegedly dominant firm abuses its dominant position, usually one member state or a part of a larger member state. So the definition then finally, where the objective conditions of competition are the same for all traders. So that's what we should look at. Another way of putting it, the second part here, the market, geographic market, is the area in which the undertakings concerned are involved in the supply and demand of products or services, in which the conditions of competition are sufficiently homogeneous, and which can be distinguished from neighboring areas because the conditions of competition are appreciably different in those areas. Some things we can look at to establish whether a sufficient homogeneous situation are what are the rules and regulations in the countries concerned. As I mentioned already, they should be the same in the EU. What about the infrastructure? How is are the roads? How is what about all kinds of bureaucratic obstacles? There you might have certain exceptions based on, as I said before, it might be difficult to transport huge industrial machines, for example, in mountainous areas, might make the market smaller. Cost and feasibility of transport, that's also linked to that example. So there are some exceptions there, but most of the time it's the entire EU. That's it, more or less. We've just haven't talked yet about the last point, and that was may affect trade between member states. Remember, that was the same in Article 101. So abuse of a dominant position is not allowed in the European Union if it may affect trade between member states. Now remember what we said about this issue under Article 101. It basically refers to to the division between the member states and the European Union in taking up competition cases. So if there's a transboundary effect, if it's a more not purely national issue, then we have a situation that may affect trade between member states. Remember, that was also laid down in Regulation 1/2003, and this distinction between tasks for the member states and tasks for the European Union. I think that's enough for this week. I hope it's clear. So what we have done is establish that monopolies, abuse of a dominant position, is illegal. We've talked about what dominance is. We've talked about percentages of market share. We've talked about additional factors that determine whether there's dominance in the market. And most importantly, we've talked about what the market actually is. And so next time we hear about monopolies, for example on cell phone market or something like that, we know that a cell phone market is distinguishable from, for example, a computer market because they're very different products, etc., etc. We're going to practice this market definition also in the last seminar, or not really the last one because we have another one afterwards to prepare for the exam. But it's the last seminar where we will discuss issues that have been discussed in the lectures for that week. So next, or this week, it will be Article 101 and Article 102, and we will have some cases in which we can apply our knowledge on these articles. So, I think I'll see you in the lecture, and otherwise I will see you in the seminar. Bye.